for Tuesday, August 30th, 2016. Can you call the roll, please?
Commissioner Shaw,
Here.
Commissioner Smith,
Here.
Commissioner Mengelberg, here. Mayor Holliday.
Aye. Here. Okay, so the only thing we have on our agenda tonight is 16-502, explanatory statement for inclusion in the Clackamas County voters pamphlet for the November 8th, 2016 general election relating to the ballot measure restricting urban renewal activities. Mr. Kunkel.
Thank you, Mayor. Evening, Commissioners. So at our last City Commission meeting, you were directed, myself and the City Attorney, to work on an explanatory statement for the ballot measure restricting urban renewal activities. We prepared a explanatory statement, which was provided yesterday, and since then we received additional comments from Commissioner Mengelberg requesting additional language in the introductory paragraph, which you have before you highlighted in blue. So that would be the additional language that's been added since this was presented and published yesterday. I'll turn it over to Mr. Kabizman. On Friday afternoon, we did email the proposed explanatory statement to Mr. Williams, and we received some a request to not submit the explanatory statement as written, that there were some concerns with some of the language in that, and then they did go to Clackamas County Circuit Court this afternoon requesting a temporary restraining order, and Mr. Kabizman can explain the proceedings associated with that and the result.
Thank you, Mayor and Commissioners. Yeah, so yesterday evening we received, yesterday during the day we received a notice that, in fact, the petitioners would be requesting a temporary restraining order to prevent the city from filing the explanatory statement. We received the actual motion last night and prepared a response this morning. We went to the Circuit Court this afternoon. The Judge Herndon heard the matter, denied their request for a temporary restraining order, but set a hearing on an injunction, essentially, that would prevent us from doing it for next Wednesday. He indicated that he wasn't convinced that that the plaintiffs would prevail on the merits, so that was part of why he denied the temporary restraining order, but there will be a hearing before possibly the same judge, possibly a different judge next Wednesday. The end result of that is that you should go ahead and put together an explanatory statement that you believe adequately does the job and adopt it. We have represented to the court that if the commission adopts an explanatory statement, we will refrain from filing it with the county until the court hearing, time set for the court hearing. So with that, let's talk about the issues that have brought up and what you need to do. For an explanatory statement, here's what you need to do. It should be an impartial, simple, and understandable statement explaining the measure and its effect. So that's what the explanatory statement is supposed to do. That's what we draft, relatively simple and straightforward. The material submitted by Commissioner Mengelberg, I think, is basically factual information explaining a little bit more about what urban renewal is. That seems to make sense to give some context to the measure for people who aren't as familiar with urban renewal as perhaps some are.
Bill, just real quick, and so we have a 500 word count limit for an explanatory statement, which this edition we still fall within that 500 words. And then can you just explain what would happen if we go to court and there's no judge next Wednesday? What would we do on Thursday?
So there is a possibility, because the circuit court is relatively overburdened. We have a hearing set for next Wednesday at 1:30, but we could be bumped for another matter that has higher priority, criminal matters and the like. If that's the case, what we represented to the court is we would not file an explanatory statement until after the time set for hearing. If it got bumped and they weren't able to reschedule it before the deadline, which is Thursday, September 8th, we would file the explanatory statement. The plaintiffs likely would try to take some action where I don't know what, but it certainly indicated that they would probably try to stop either the city from filing the explanatory statement or the county from publishing it. You know, we can't really control that, but all we have done is agreed to hold off on filing it with the county until the time set for the hearing.
Okay.
So with that, turning back to the said Commissioner Mengelberg's, it seems pretty straightforward. When we look at impartiality, it's, you know, does it advocate yes or no? And also, you know, if it talks about benefits, does it talk about costs? You know, there's no advocacy in there. It's facts about urban renewal. It talks, you know, provides how much debt has been involved as well as the increase in assessed value. So it seems factual and impartial. Some people may have a different opinion. I don't know. The other comments from Mr. Buss, who represents the petitioner, Mr. Williams, former Mayor Williams, in this matter, bring up two issues. The first is that the city doesn't have authority to file the explanatory statement. And this has to do with an administrative rule that says for any initiative by referendum, an explanatory statement shall be submitted only if the local government has an ordinance requiring the submission of such a statement. The city has ordinance 1.30.010, which basically authorizes and designates a city recorder and city manager and city attorney to draft the statement and to bring it to the city commission, who will review it and approve it. The comments fault that ordinance for not using the word required. I'm not certain that it's necessary that it says required. When you read it and it's referenced to the administrative rule and the context of how it was adopted, it seems pretty clear that the intent of the commission was to require the submission of an explanatory statement. I've also prepared a short resolution that I'd recommend you attach with it, where it specifically says that the city has adopted, city commission interprets 1.30.010 to require the submittal of the explanatory statement, so that, you know, it's clear to the court that this is how you interpret it, that it should, you know, that we're required to submit the explanatory statement. So we'd recommend that be in there. The second piece is they challenge the second paragraph, the last paragraph in the one with Commissioner Mengelberg's comments, and essentially says that the proposed explanatory statement is not impartial. It is also speculative and confusing, which, you know, the basic gist of their complaint is that even if the measure that this paragraph states or suggests that this measure will have no effect even if it is passed. And I think that we're required by the statute and the administrative rule to explain the measure and its effects. And if we believe that this measure is not going to have an effect because it shouldn't be in the city charter, you can't control an urban renewal agency through the city charter, then that's an effect that we have to identify in the explanatory statement.
And in fact, we not only have received a legal opinion in that regard, but sent a letter to Mr. Williams to that effect several months ago, right?
Actually, last December, and then the city elections officer, the city recorder, rescinded the certification based on that, and another theory about the administrative legislative that gets. I don't want to get too far down in the weeds,
right.
and we ended up in a different court case on that, and essentially the court in that case said the city didn't have the authority to rescind the certification, but it doesn't change our opinion.
That was based on a time frame, not
Correct.
any merit.
No, they did not reach the merits of that at all.
Okay.
So that's where we are, and I guess your job tonight is to look at the comments submitted and the explanatory statement and decide what the explanatory statement you'd like submitted to the county clerk to appear in the voters pamphlet with this.
Can you pass me that resolution?
Oh, I'm sorry, yeah. Go ahead and everybody.
Okay. Is it on the back?
No, it's here.
Oh. Okay. Never mind. No, it's not. No, it's not.
No, it wasn't in your packet tonight. I
Okay.
apologize.
The rest of these? Almost tipped over your Snapple. Okay, I'm good with that. So is there some discussion on the actual wording of the measure, or the explanatory statement?
Well, or the resolution anyway.
Or the resolution as
Yeah, I
it's
think the
presented?
resolution's fine. Now we can move on here. Is everybody okay with the resolution now?
And I think we should clarify too that what you were speaking off of is something that was just submitted for the record, right?
Correct, the letter from Jesse Bust,
Okay,
August 30th.
was just submitted today for the record, so I just want to make sure that that's been stated.
So I'm gonna,
This is not court stuff.
I'm gonna, because we didn't include public comment on the agenda, but it is customary for us to do that. I'm gonna take the public comment now before we have the discussion. That's okay?
Yep.
So I have one card, Mike Mitchell.
Thank you. Good evening. Mike Mitchell. I'm an Oregon City resident. And in the big scheme of things, this is probably a very small thing, but it's only going to take me a second to explain it, so I guess that's okay. My concern is the wording in the first bullet point where it says, would prohibit the commission from financing an urban renewal plan or project with tax increment financing. That reads singular to me, and that might be construed as affecting perhaps one project. All I would suggest is that that wording say financing any renewal plans or projects with tax increment financing. So it makes it very clear that what the full scope of this measure would be. That's it. Thank you.
Thank you, sir.
Thank you, Mike.
Jesse Buss.
Thank you, Mr. Mayor, Commissioners. I'm here representing John Williams, and because there are ethical restrictions about communicating with an opposing party with pending litigation, I'm going to be careful here. I just want to reiterate that my client, for all purposes, resubmits the letter that I submitted this afternoon, and those same comments apply to the revised explanatory statement that was just distributed. And to the extent that the resolution was not included in the agenda, and there was no notice that this resolution would be coming forward, we would object to the lack of notice to the public on that. Thank you.
Okay. Any further comments from the public? All right. So we're back to discussion. I'm fine with the amendment suggested by Mike. Anybody have any further changes?
So the first sentence would read, the measure would prohibit the city or the Urban Renewal Commission from financing any urban renewal plans or projects with tax increment financing?
That's correct.
Yes. Any issues with that, or you
No.
fine?
No.
Okay.
No.
It's a good catch, actually.
Yeah.
Well, come on up, John.
No, it's just technical.
Well,
It has
in
to
order
be
for
on the mic.
to be on the record, you got to come up to the microphone.
Well, the city manager referred to a 500-word limit.
Correct.
Is that a different qualification than a regular entry in the voter's pamphlet? Because it says 325.
It is a different limit.
A different limit?
Yeah.
Okay, didn't want to make a mistake.
Yeah, thanks.
I was surprised too. Okay. So what's the word count on this?
Somewhere around 323.
Yeah.
Got 175 left.
I believe it was Oscar Wilde who said brevity is the soul of wit.
There you go. Well, looking at the last paragraph, everything that I have heard in the last year and a half from all of our legal resources says that to their best ability, they believe that this is actually true. And truth is the only thing that we're talking about here. So, brevity, I don't think, or, short, simple, while it might be a goal, isn't a requirement. So unless someone else has some edit.
No, I'm good. I appreciate the length of it because urban renewal is kind of a complex tool. And we could talk about this for 3 more pages if we wanted to. So I think that having it in this form is the best way to go here. And I would like to thank Commissioner Mengelberg for doing this addition.
Commissioner Smith, would you like a couple minutes to finish reading?
I apologize. I have a migraine, and I'm just trying to get through. I want to at least get through this before I.
Take your time. I guess I would like to see something in that first paragraph, because we don't talk about blight, and blight is a key piece of the urban renewal statute. And I think we can make a fairly positive argument that we have eliminated a lot of blight downtown with the storefront improvement grant program.
Be careful, we don't want to make an argument in the explanatory statement. I do think it's important to I think it makes sense to say it's designed to alleviate blight, or I'll track down the statute and see what it says.
So how about if we say directly, so we're 1, 2, 3, 4 sentences down, after comma, stimulating private development, reducing or eliminating blight, and fulfilling Metro Region 2040 growth concepts.
That's fine.
Yeah.
What was that again? Something in eliminating?
So after
Yep.
after the comma, after stimulating private development, reducing and eliminating blight, and fulfilling the Metro blah blah blah. Reducing or eliminating blight. So Katie, you have a copy of this, right? Can you distribute the link to the report to the rest of the commission?
On this.
To what?
Do we have the statistics for that?
What do you mean? I don't know. I assume those are
These statistics came from
So that last sentence is accurate.
as,
Right. I hope so.
as accurate
Or
as
it
we
shouldn't
can.
be there.
Well, that's what I'm saying.
It came from Mr. Underwood,
Okay.
right?
The numbers actually came. Wyatt, did those numbers, the first set of numbers, come from you and your team?
You're questioning the maximum indebtedness of the district.
The debt has
The
been
assessed
issued, the assessed
value.
value, and the estimated value.
That is correct. Those
So-
are accurate numbers.
Thank you, sir.
Okay.
When you're done, one other minor amendment to the resolution. It's a special meeting, not a regular meeting of and the last sentence.
Oh, okay.
Resolution?
Yeah, it's just changing the regular, because this is a special meeting.
Okay.
I don't know. I'm reading all this. The first version was everything as it is except for the blue edition that was
Correct.
Just remembering here, Wyatt, but I think that the figure you've listed here, the $50.7 million is an error. If you meant at what date? There was a $68 million value when it was first formed, and then in 1996 or something like that, there was a revision of the whole law at that time statewide, and they dropped the frozen value down. So I don't know which one you were looking at, but this is an adjusted value, the 50.7 million. It was a higher value than that to start with.
Thank you, John. Renata, did you have a comment on that, or
I wouldn't know.
I actually, those numbers were there
Yeah.
previously, so
If you want me to call you with that figure, I
yeah,
can
we
quote it
could
for you
we could look at
directly.
that and just clarify those numbers.
Unless that's gonna hold things up, I don't know, I just.
Yeah, could you make that comment one more time? Just repeat your.
The original frozen value was, I think, 68 million. When they made the Measure 5 and all the confusion, they set values back a couple of years on homes. They lowered that value, the frozen value, to give the agency more money. It was about 1996.
I got this number from information that Mr. Underwood provided me, which was from the current assessor's report, the most recent assessor's report.
That's what I thought where the numbers came from, but I can double check on the assessor's report if that would. You think that would satisfy that, John?
I guess the key is the
county
assessed
assessor.
value at formation. Do they mean formation, reformation that happened in 96, or do they mean the formation of the urban renewal was in 1983? And
Why-
that's when that higher value was established.
Let's do this. Why don't we check with Assessor Roman and verify that either there was or there wasn't an adjustment at the time, and whatever the actual historical number, that's the number we should use.
I'll clarify first thing tomorrow morning with the county assessor.
Just you want to get it right, that's all.
Yeah, thank you for that. Appreciate it.
Are you ready to discuss?
Yeah. I'm
So
ready.
I would entertain a motion with the amendments that we've put in place and with the proviso that we allow the finance director to confirm or revise that valuation at formation number, depending on the information received from the Clackamas County Assessor's Office.
So you're looking for the original formation value.
Right. So is somebody,
Second.
no, I can't make the motion. I was asking for a motion.
Okay. Move to accept the explanatory statement with amendments agreed to today, including any adjustments needed to the original assessed value of the district.
Second.
Discussion?
Just to be clear, that would also include adopting resolution number 16-28.
With the change noted of special, replacing the word regular with special in the last sentence.
So, okay.
Do we? So you asked if there's a different way to summarize that bottom paragraph. Was that the one and only version that we attempted?
I think I took the first cut at it and went back and forth with another attorney, Carrie Richter, in our office to take a look at it. I'm trying to think if we exchanged any comments. I know that we had certain staff members look at it. I believe Tony and Katie and I believe Mr. Underwood. So I couldn't. I can't tell you how many versions we went through.
Are you confident that that this is a fair and truthful statement and does not either advocate or not advocate for the measure?
I believe it's a simple, understandable, concise statement of the measure and its effects.
Thank you, sir.
Did it get looked at by anyone else? I mean, typically, don't we run these?
So we have run them explanatory statements in the past by the Secretary of State's
Right.
office. They will no longer review explanatory statements.
Yeah. I asked that question earlier today, so.
Because that bothers me.
Is there a certain aspect of that paragraph the whole paragraph or the last sentence, or that we could?
Well, it bothers
discuss?
me knowing we don't have an insurance
Oh.
other than
Yeah, it'd be
our
nice.
own attorneys,
Yeah.
to really look at that. And I'm not saying I don't believe it's fact, but if we find out later there's some things in there that are a problem, I have concerns about that. I just reading it, it is complicated and it is very hard to understand for the general voters. And
Well, but urban renewal in and of itself is complicated and hard
absolutely.
to
Sure,
understand for the
absolutely.
general voter. So
Absolutely.
how do you take something that is complicated and make it into a comic book?
But
And-
the first paragraph, I think, gives us a clearer
Right.
statement, and the bottom one is obviously a little more technical. So I'm happy with the addition of the upper paragraph.
Yeah, I am too.
now, which gives us a little clear understanding for the layperson about urban renewal.
I mean, how many hours have we agonized over this with not only city attorney, but with our urban renewal attorneys?
Commissioner Smith, one thing we could do, we've done this in other situations where the Secretary of State doesn't review things. We could say this is not an explanatory statement or not. We could say this is material we want to put out and have them review it for impartiality. And that's really what the Secretary of State reviews for, is impartiality. They're not going to review for necessarily accuracy.
So we just don't tell them it's an explanatory statement. We say it's something we want to use for educational purposes?
You know, I have to think through exactly how we would term it, but, essentially ask them to review this for impartiality.
How long does that typically take?
24 hours.
I'm okay with
Then
that.
let's do it.
Okay.
So
Good.
what I would suggest is you adopt it now. We've already agreed not to file it until Wednesday next, and so if there's a problem, we can bring it to you at the City Commission meeting next week and amend as needed.
Yeah, I don't want to have that problem later.
I agree with you.
Yeah.
That was a new light bulb there for
Yeah,
Mr.
good one,
Kabizman.
a good one.
Because I asked that question earlier today, and they said there was no way to do that, so.
Okay.
All right, we have a motion and a second. Motion by Commissioner Mengerberg, seconded by Commissioner Shaw. Is there any further discussion?
The motion was the explanatory statement and the resolution. Do we need to include the
No, I think that's,
addition of?
I think that's just staff. They're
think
gonna
we
do what
understand- we
they're
think we
gonna do what
understand our
we've directed them
direction.
to do, and if it comes back and there's a problem, then we have time to correct it at our September 17th.
But the motion is contingent on that answer, right?
I think what I would ask that you not make the motion contingent on the answer. We go ahead and that you go ahead and adopt it, and we bring it back to you if there's a problem.
If there's a
Got it. Okay.
Further discussion? No? Call roll, please.
Commissioner Shaw?
Aye.
Commissioner Smith?
Aye.
Commissioner Mangelberg?
Aye.
Mayor Holliday?
Aye.
Passes unanimously.
So, there isn't anything else on the agenda. I did want to make mention of the fact that the filing dates for the city commission seats closed at 5 o'clock this afternoon. And as of that time, Commissioner Mangelberg, who has filed for her seat, did not draw an opponent. Nancy Ide, who filed for
My seat.
Commissioner Smith's seat, did not draw an opponent, and there are two folks or three actually, Ray Gordon, Paul Espy, and Frank O'Donnell in the remaining seat. So that is where we are as of today, and we'll move forward towards the election. Is there anything else for the good of the order?
I just passed out a letter dated August 30th, 2016 to the Gladstone City Council from County Chair Ludlow,
Yes.
just for your reading pleasure.
This is what Commissioner Ludlow is going to read into the record at the Gladstone City Council meeting tonight. Do you have a copy of this for the record?
I do.
Okay. All right. Nothing further. We're adjourned.
All right.